You put your 74-year-old father and 72-year-old mother on the sidewalk in January? The question hung in the air so hard it seemed to lower the temperature in the room. Kyle Bennett didn't answer right away. He leaned back in his chair, chin lifted, one ankle resting on a knee like he was in a contractor's office arguing over an invoice, not sitting 3 feet from the parents he had locked out of a house before sunrise. His mother, June, stared at her folded hands. His father, Harold, sat rigid beside her in a brown suit that had been pressed too many times and worn too long. And then Kyle made the mistake that changed the entire case. "It's my property," he said. "They were guests. Guests leave." Judge Judy looked at him over her glasses with the kind of silence that makes arrogant people talk too much. The audience felt it instantly. So did Kyle. Because this was not going where he thought it was going. At first glance, it looked like a routine family dispute dressed up as a courtroom spectacle. A son, elderly parents, a house in Toledo, Ohio, a demand for $5,000 in moving costs, motel bills, replacement medication, and storage fees after an ugly lockout. Kyle came in believing title solved everything. The deed was in his name. The utilities were in his name. The mortgage was in his name. He assumed that meant the story ended there. It didn't. Because what he called a simple property rights issue was, in reality, 4 months of carefully documented betrayal. The lockout was only the visible part. Underneath it was a quieter story about retirement money, handwritten promises, a rushed transfer, and a son who had figured out something ugly and useful. If the people you're exploiting are old enough, ashamed enough, and still hoping you'll behave like family, you can get away with more than you should. That was his theory. Judge Judy was about to destroy it. If you appreciate stories where power finally meets consequences, stay with me. Because once the paperwork opened, this stopped being a bad family argument and started looking like a calculated takeover. The Bennetts had spent 36 years in the same ranch house near Sylvania Avenue. Harold had worked as a machinist at a transmission plant. June spent 22 years in a public school cafeteria. No dramatic wealth, no inheritance windfall, just careful savings, a paid-off home, and the kind of people who kept receipts in envelopes labeled by month. In August of 2025, after Harold suffered a mild stroke and could no longer drive regularly, Kyle proposed what he called a practical solution. He was 45, recently divorced, and said he wanted to keep the family together. He found a duplex on Birch Hollow Drive listed at $189,000. He told his parents he could qualify for the mortgage if they helped with the down payment and early repairs. In return, they would have the first-floor unit for as long as they needed. Rent-free, stable, close to doctors, close to him, safe. That word mattered later, safe. The Bennetts sold their old house. From the proceeds, $41,800 went directly into the new arrangement. There was a cashier's check. There were contractor receipts. There was even a handwritten note dated August 14th, signed by Kyle, saying, "Mom and Dad have lifetime first-floor residence. No rent. Family agreement." Kyle would later call it a meaningless note. Judge Judy did not. For the first 6 weeks, the arrangement held. Then Ashley moved in. Ashley was Kyle's new girlfriend, 29, loud, volatile, and according to neighbors, suddenly very interested in fixing up the place. The downstairs unit the Bennetts had been promised began filling with box tile, paint cans, and furniture deliveries. Kyle started talking about short-term rentals. Then came the first push. He asked June and Harold to move upstairs for a while. Then he wanted them to contribute to the electric bill, then groceries, then internet, then what he called their share of furnace repairs. 1,000 little revisions to a promise that had originally sounded simple. By December, the Bennetts were paying money into a home they had already helped purchase. Then came January 11th. It was 6:18 in the morning, 27 degrees outside. Harold opened the front door to bring in the newspaper and found the key no longer worked. Their coats, medication bag, and 2 plastic bins had been left under the carport. June's blood pressure tablets were still in the kitchen. So was Harold's cane. Kyle stood inside the locked storm door and told them, according to June, "You should have listened when I was being nice." Kyle denied saying it, but the problem was proof. June produced motel receipts from the Redwood Inn for 11 nights, storage invoices, pharmacy replacements, a tow bill for Harold's mobility scooter, and then Judge Judy asked the obvious question. "Did you file an eviction?" Kyle shrugged. "I didn't need one. They weren't tenants." That was when the story stopped being ordinary. Judge Judy leaned forward. "You don't get to skip due process because the people you're putting out are old and inconvenient." Kyle tried to recover. He said they were aggressive, said his father yelled, said his mother interfered with contractors, said Ashley felt uncomfortable. It was a mess of excuses, each one landing flatter than the last. He kept returning to the same point: his house, his rules, his right. Then June opened the second envelope. Inside was the detail that changed everything. Not just the cashier's check for $41,800, not just the August note. There were text messages, screenshots from September through January, one from Kyle to June. "Once refinance clears, I'll pay you back some." Another from Ashley to a friend, printed and highlighted because June had gotten it from a relative who was accidentally included in a group chat. "We just need them out before spring so we can Airbnb the lower unit." And then the line that turned the room cold. A text from Kyle on December 28th at 11:43 p.m. "You already served your purpose. Stop acting like owners." Harold didn't cry when Judge Judy read that out loud. He just stared at the table, which somehow made it worse. Kyle's posture changed after that. The confidence drained out of him in visible increments. He started interrupting, started claiming context, started saying everyone was misreading him. Judge Judy shut it down. "No," she said. "What I'm reading is intent. You needed their money to buy the property. You made a residence promise to get it, and when your plans changed, you removed them without process in the dead of winter. That is not a misunderstanding. That is a scheme with central heating." The audience laughed once nervously, then went silent again, because the truth had settled in. This was never about boundaries. It was about leverage. Kyle took the one generation trained to sacrifice for him, used their retirement equity to secure the property, then relied on title law and their own shame to keep them quiet when the arrangement became inconvenient. He thought age made them weak. In that courtroom, it did the opposite. It made every act against them look exactly as cruel as it was. "If you believe no one is above accountability, stay with me." Because the next 5 minutes were the tables turning in real time. Judge Judy went through the damages line by line. $1,586 for emergency lodging, $612 in medication replacement and medical transport, $1,940 in storage, $318 in locksmith and towing charges, the rest for clothing and personal items damaged during the removal. Total requested $5,000, maximum claim, fully documented. Then she added something more devastating than the money. She said on the record that if this had been a higher jurisdiction civil court, she would expect claims for fraudulent inducement, unlawful self-help eviction, and conversion of contributed funds. She told Kyle that holding legal title did not erase the promise used to obtain the money. It simply made the betrayal easier to map. He tried one final defense. "They're my parents. I was going to work it out." Judge Judy didn't even let him finish. "No, you were going to enjoy it. That's different." There are moments when a courtroom stops being a place for arguments and becomes a mirror. That was one of them. Kyle looked down. For the first time all day, he had nothing to perform. Judgment for the plaintiffs, full $5,000. But that should have been the end of it. It wasn't, because once the episode wrapped, the case had a trail now, a documented one. The Bennetts took that ruling, those exhibits, and the transcript to legal aid in Lucas County. A housing attorney helped them file a larger civil action. The lender reviewing Kyle's refinance request flagged the parents' contribution documents and the resident's promise. The refinance stalled. A lien followed during settlement talks. 4 months after he had stood behind a locked storm door telling his elderly parents they were just guests, Kyle was the one facing deadlines, scrutiny, and a property he could no longer easily leverage. The eventual settlement never got him all the way back to what he lost in that courtroom. June and Harold recovered a portion of their contribution, enough to secure an apartment near her sister in Maumee. Kyle kept the duplex, but not the advantage, not the story, and not the excuse. Because what Judge Judy turned that day was not just a ruling, she turned the frame. She took a son hiding behind ownership papers and showed exactly what was underneath. Greed dressed as authority, entitlement dressed as practicality, cruelty dressed as property management, and that matters because cases like this expose something bigger than one family. The most damaging betrayals rarely begin with shouting. They begin with access, a spare key, a bank transfer, a promise made at the kitchen table by someone who knows your routines, your fears, and exactly how long you'll keep calling abuse a misunderstanding just to avoid saying your own child did this to you. At the end, as Harold and June gathered their papers, Judge Judy looked at them and said, "You were not thrown away. You were used. There is a difference, and the law can still see it." That was the final reversal. Kyle thought the deed made him untouchable. He thought age would silence them. He thought 4 months was enough time for humiliation to harden into surrender. Instead, it became evidence. If cases like this make you think, let me know in the comments. Because the coldest people are not always strangers. Sometimes they are family members who mistake patience for weakness and kindness for permission. And when that calculation finally fails, the sound it makes is not dramatic. It is quieter than that. It is a judge reading the truth back to them line by line until ownership means nothing and character means everything.